Glynn.
Yes, my Lords, if I might pick up on some of the queries that were raised with me about the factual background first. I was asked about the recommendation of a single commissioner. That can be found at 417 of the bundle. This was a recommendation made on the 7th of October 2016, and it's a short document, but the circumstances of recall are set out at page 419, paragraphs 10 through to 12. The test applied by the parole commission is identified at 13. It's the bottom of page 419, and it refers to whether or not there's evidence that proves on the balance of probabilities a fact or facts indicating the risk of the offender causing harm has increased significantly, more than minimally, since the date of release, and the risk cannot be safely managed in the community. And there's a rationale set out, which I won't read, but paragraphs 19 and 20 identify the parole commissioner's view that the risk of causing harm to the public had increased significantly, more than minimally, and could be managed in the community. Hence the recommendation to the department to recall.
Is that the correct test?
That's the correct test for.
Is it?
Yes.
In accordance with the statutory provisions, is it?
Yes, Lord, it is.
Would you ask them to come in, please? I'm sorry about this, Lynn, and if you bear with me for a moment, I hope we'll be able to sort it.
Were you on page 319?
No, sorry, my Lord, I'm on 421.
421?
Yes.
Thank you.
Can you just help me in relation to 421?
421 is the.
Does that start official sensitive?
Yes, it does. That's the final.
The DCS licence.
Yes, that's the final page of the recommendation of the commissioner.
Thank you very much.
And
Why is it necessary, if you have a determinate custodial prisoner who is automatically released, why is it necessary for the parole commissioners to determine that the risks have increased as opposed to there being a risk?
well, this flows from case law from the Northern Ireland High Court, case of Foden and others, which have examined this issue and have articulated or put a gloss on the test. So the parole commissioners are picking up on a body of case law in the 2008 order, and that's why the test is expressed in those terms.
And which authorities?
I think the decision is Foden that gave rise to that clause. So it's a combination
And which court decided that?
I think it's the Northern Ireland High Court.
Do we have it in the bundle?
Tab 27 of the bundle. You don't have tabs, but page 2054.
But it's illogical to think of a risk increasing if the release is automatic.
Release is automatic at the 50% point or earlier. Then the behaviours that arise thereafter are assessed, and they give rise to a more than minimal increase in risk. And on that basis, the High Court has indicated that's the approach to be adopted by the commissioners, and that's the approach they've adopted thereafter. So that's the source of it. The department's role then is to respond to that recommendation, which they do, and Lord Seals asked me about that. The relevant letter is at 463 of the bundle. It's 21st of October 2016. It refers to the revocation of the licence, refers to 28.2 of the order, sets out all the material that was considered, and at the bottom notes that the department is satisfied the risk of harm imposed to the public has increased more than minimally since you released on licence, and they conclude it can no longer be safely managed in the community, and on that basis he's recalled. So that's the approach, and you'll see again the next paragraph, the last line, expresses again satisfaction that he was involved in behaviour that significantly and more than minimally increased the risk of harm imposed to the public. And that was the department's basis for the recall. Then, leaving those factual points for the moment and going back to the legislation, over the short adjournment, we sent in, I'm not sure if my lords got it, but we sent in PDFs of the contents title page and all of Part 2 of the 2008 order.
Yes.
Because
Thank you.
I was making the point that it's visually illustrative of the differences and the overall approach in respect of that order. The 2008 order is not a simple replication of the Criminal Justice Act 2003 in England, so it's not a direct parallel. It was a piece of legislation which drew upon the 2003 Act, but which had some additional refinements. I don't need to go into it in any detail, but for your own record, the first affidavit of Mr. Allison from the department is at page 444 of the bundle. Don't need to open it. And 444 to 45, he sets out the legislative history of this provision. And it was a wholesale reform to sentencing law and practice in Northern Ireland. It abolished remission, introduced the concept of public protection sentences. It created the parole commissioners, who previously didn't exist, and brought into play a regime of early release on licence, subject to conditions. So this was a bespoke piece of legislation. And the contents page that I've referred you to shows that Chapter 2 dealt generally with custodial sentences, and the DCS sentences fall within that part of the framework. And then Chapter 3 deals with dangerous offenders. So the comparators, all of the comparators here, fall in a different part of the legislation, the dangerous offenders element of the legislation, which itself has been amended subsequently to include specific sentences for terrorist offenders. And that's a 2021 amendment introduced that. But stepping back, what the court will see here is a statutory scheme that creates a number of different sentencing regimes. So you have DCS, then you have the dangerous offender sentences, the public protection sentences, which are the life sentence, the indeterminate custodial sentence, the ICS, the extended custodial sentence, the ECS, and then different variations of terrorism sentences. Each of those in our submission is a hermetically sealed sentence structure, which has its own entry conditions and internal provisions. And that is key to the analysis in this case as to whether or not there are analogous circumstances allowing us to compare one with the other. And we say there are not. Now, when this court dealt with a similar argument in Stott, the approach Lady Black took in a very careful judgment was to actually analyse in detail the different sentences that were being compared and then apply that to the Article 14 analysis. And we say the same approach would be of assistance here. I'm not going to overburden the court with detail, but if I might just sketch how the different sentences that are in play here work. And I've touched on the DCS, moving now into Article 13 of Chapter 3 of the order. You come to the ICS.
The page number?
Sorry, that'll be at 990, I think. So we're in dangerousness, we're in public protection chapter, and this provision deals with life sentences or indeterminate custodial sentences for serious offences. The appellant does not seek to pray and aid the life sentence, but does pray and aid the ICS, although no real submissions were made about that today. But again, it's important for the court to see the totality of the sentencing regimes. So 13 applies where a person is convicted on indictment of a serious offence. That's a defined term, which refers to the offences identified in Schedule 1. And then additionally, the court is of the opinion that there's a significant risk to members of the public of serious harm occasioned by the commission by the offender of further specified offences. So it's not just serious harm. The court will look to see the entirety of that. There are a number of elements. So it's serious harm occasioned by the commission by the offender of further specified offences. And there's a degree of detail in that which is also relevant to recall and the management of licensing. So we're not just looking to any behaviour that causes risk to life or limb. It's something by this offender that will give rise to further life and limb offences. So it's quite a refined threshold concept that's in play there. But if that threshold is satisfied, you have your serious offence and the court's satisfied on those issues, then the option opens up for a life sentence or an indeterminate custodial sentence or possibly an ECS. And looking down to 13.3, you'll see that if the court considers an ECS or a serious terrorism sentence would not be adequate for the purpose of protecting the public from serious harm occasioned by the commission by the offender of further specified offences, the court shall impose an indeterminate custodial sentence. And here again, the structure is specific and detailed. You will see at 3B, this sentence has an element which is a minimum period. So there's a minimum custodial period of at least 2 years, maybe longer. But this is a unique feature of the ICS regime. So there's no prospect of consideration by parole commissioners in that period. The next sentence that's available but not relevant for our purposes is at 993, the serious terrorism sentence. I can pass over that. Article 14 contains the detail in respect of the ECS, and the ECS has been the mainstay of my learned friend's presentation today. And again, the threshold concepts for the imposition of the sentence are conviction or indictment of a specified offence. There's a temporal point in respect of when the offence was committed, and then again the risk condition in the same terms, risk to members of the public serious harm occasioned by the commission of the offender of further specified offences, and that it's one that it's not appropriate to impose a life sentence or an ICS. And one looks across to 997, this is subsection 2. Again, Mr. Sully's touched on this, an obligation to impose an ECS, and then the detail of it is set out at subsection 3. The sentence which is equal to the aggregate of the appropriate custodial term and the further period, the extension period, for which the offender is subject to a licence for the same reason, risk of serious harm, with the detailed test. So the ECS sentence is again structurally different from the DCS. It has a different consideration in terms of the licence period, that's risk of serious harm. It can be contrasted directly with Article 8.5, which is the harm condition for the DCS. Different chapters, different test at the entry point of the sentence. The ECS prisoner is not released automatically at the 50% point or the halfway point of the custodial period. Like the DCS prisoner, they can apply to the parole commissioners for release, and I'll come back to that when we come to look at Chapter 4. There are limits to the extension period in subsection 8. You'll see that at page 998. So depending on the type of offence, there are maxima that apply in respect of the extension period, and there's no remission for those sentences. Article 15 is where dangerousness plays in. A question was asked earlier on today about where that emerges. This whole chapter is about dangerousness, but Article 15 has a specific provision as to how it should be assessed. And this applies only to the public protection sentences, not for DCS. And you'll see what or how it has to be done. There are some mandatory considerations and some discretionary considerations for a court in conducting this exercise. So again, that's built in to the structure.
Does that provision affect both sentences under Article 13 and Article 14?
Yes, it does. And the serious terrorism sentences as well, I think. Yes. So, Chapter 4 then of the Part 2 of the order deals with release on licence, so a separate component of the statute. I think you've had that open to you. If I can take you to page 1006, you'll see the Article 17 duty. And this is the duty to release once the individual prisoner on a fixed term sentence has served the requisite custodial period, they shall be released on licence. And that's the custodial period specified by the court under Article 8. So going back, this is the DCS sentence. The judge will specify what the custodial period is, up to a maximum of 50% of the overall sentence, possibly less. When that time is served, there's a positive duty to release the prisoner at that juncture. The important point is there's no intervention at all by the parole commissioners. No qualitative assessment of risk takes place at that point. The assessment of risk is actually conducted at the sentencing point by the judge, and the concept is he reflects or she reflects that risk in the duration of the licence period and the sentence as a whole. So there's no qualitative assessment of risk. That can be contrasted with Article 18, page 1007, which makes provision for the duties in respect of ICS and ECS prisoners. So you will see 18.1 identifies the cohort that are in range here, ICS and DCS. There's a definition section in subsection 2, and it refers to the relevant part of the sentence. I'll highlight that. So for an ICS, the relevant part of the sentence is the period specified as the minimum period. So that's at least 2 years, or possibly significantly longer. Or in an ECS, 1/2 of the period determined by the court as the appropriate custodial term under Article 14. So the relevant part of the sentence is then re-engaged at subsection 3. As soon as the prisoner has served the relevant part of the sentence and the parole commissioners have directed their release under this article, the department shall release them. I'm just pausing there to work through an example of how this will work. Hopefully this helps. Let's say we have a DCS prisoner who's been sentenced to a 4-year sentence, 2-year custodial term, 2-year on licence. So at the end of the 2-year custodial period, that person will be automatically released, but at risk of recall during the licence period. Let's take an ECS sentenced to a 4-year term with a 2-year extension period. That person will be able to apply to the parole commissioners for release at the 2-year mark. So in a similar way to the DCS, it's automatic for DCS, it's eligible to apply for the ECS. If they are released, they will serve 2 years. They will have the remaining 4 years on licence. If they are recalled, then they are returned to custody, and they are at jeopardy of serving the entirety of the 4-year extension period. So one can see how the risk reductive exercise works. The prisoner will know if he is released, applies successfully, is released after 2 years, is back in the community. If he's recalled, he's at jeopardy of serving a 6-year term, subject to the parole commissioners releasing him again if he is no longer posing a risk of serious harm. So it's an entirely different conceptual model. The risks.
This is maybe unrealistic, but in principle, if the prisoner is recalled, let's say, after they've been out on licence 1 year, could they then reapply to the parole commissioners for future parole?
Yes.
I appreciate if they've been recalled, they may have difficulties in establishing they don't pose any risk at all. But
They can apply, yes.
Okay, I just wanted
So
to
you apply. Parole commissioners at that point are applying 28(6)A as the test. So are you posing a risk of serious harm of of committing a further specified offence, and if not, then there's a possibility of release. If you are, then they're disempowered from exercising the discretion. So yes, but looking at how it's meant to work to disincentivise the dangerous offender, they have much greater jeopardy by breaching their licence conditions than a DCS prisoner does. DCS prisoner breaches the licence conditions, they can be recalled up to the end of the original licence period. ECS prisoner breaches licence conditions, they face a very significant extension of their sentence. But the court, I hope, can see that these are very different models.
And that's apart from the greater jeopardy that might already exist because of the likelihood of a longer sentence in the first place.
Exactly. I don't accept the appellant's premise that it's the same for a DCS as an ECS in sentencing. If you're in ECS territory, as Lord Stevens observed, the likelihood is it's going to be a dangerous case, and the sentence will be higher, more significant.
And also, any licence conditions are likely to be more stringent as well.
More onerous, yes, tailored to the offending and subject to, obviously, close scrutiny. The other feature that doesn't emerge directly from the statute is the release, the eligibility for release is subject to application. The consideration of the application by the parole commissioners is usually subject to demonstration of risk-reductive work or rehabilitative work. So you'll see reference in the affidavits of Mr. Allison to the fact that these prisoners, the ECS prisoners, will usually not be released unless they've been tested in the community, either by temporary releases or unaccompanied temporary releases, or by conducting other work. That doesn't happen with a DCS prisoner. So, one can't leave out of account the fact that the 2008 order introduced this entirely new concept in Chapter 7 of the parole commissioners, with this qualitative risk assessment function based on information about how the prisoner actually was performing. And that's engaged for the ECS, but not in the same way for the DCS.
Well, I can understand that in practice there are those provisions, the prisoners are tested in the community before being released. But do we have to consider the statutory framework as opposed to what actually happens in practice?
Yeah, I fully accept that, my Lord, yes. I mean, this is a challenge to the compatibility of the statutory framework. Yeah. What happens outside of that is not okay. Well, I say it's background.
Well, it's been accepted that obviously the licence conditions are going to be more severe, and I suppose it could be equally accepted that the preconditions for release would be more stringent.
Yes.
And involving testing.
Well, the court has evidence to that effect in the papers. Mr. Allison's affidavits deal with that. It's not my simple observation, Lord. So.
And can I just check what you say about Article 18.4, because that seems to have the same structure as Article 28.6.
Yes.
A. So 18.3 says, where the parole commissioners have directed release, Department of Justice shall release on licence. But then 4 says the parole commissioners shall not give a direction under 3 with respect to P unless the case has been referred to them and they are satisfied it is no longer necessary for the protection of the public from serious harm.
Yes.
Now that seems to set a limit to what the commissioners may do, but doesn't tell them what they should do when they're outside that limit.
Yes, I think on the face of the statute it doesn't do that. I think, again, in practice, the commissioners use this as an operating tool, essentially. They apply this as the threshold condition. Whether or not there is a need to protect the public from serious harm is what they use.
I thought you said before lunch that the guidance contained a discretion.
Well, I looked at it more closely. It's not quite as clear that it does contain a discretion. And I mean, we're not here. I'm not representing the parole commissioners, but I think in practice there isn't a significant discretion being exercised. It seems to be available on the face of the statute. It's not constrained. Practice may differ from that, but I think our submission is it's not critical to the determination in this case.
Right, but you would say that 18.4 is to be read as imposing a limit to what the commissioners may do, but it doesn't take away all discretion from
not at all.
or indeed pose what test they should apply. So they may choose to apply this as a test, but that's a matter of exercise of their discretion in adopting a policy.
Respectfully accept that, Lord, yes.
Right, okay.
18.8 is also important. That's 1008. Where the prisoner is serving an extended custodial sentence, the department shall release them on licence under this article as soon as the period determined by the court as the appropriate custodial term under Article 14 ends, unless previously recalled under Article 28. So on my 4-year model, you get to the end of the 4-year appropriate custodial term, you are released unless previously recalled. If you're recalled, then release is contingent upon satisfying the test for release in Article 28(6).
Can I just ask you this? You were very careful earlier on to point out that at the earlier stages in which the statute is referring to an ECS, the relevant phraseology is protecting the public from serious harm by the offender of specified offences.
Yes.
In the provision to do with recall, so we're on, 18.4a, 18.4b, I beg your pardon, we don't see the words from serious harm committed by the defendant or whoever it might be by the commission of specified offences. Are you saying that's implicit?
No, the same is true also of 28(6)a, which is the release after recall provision. So the release and the release after recall don't have that special element or the additional element of commission of a specified offence by the offender. So the commission of the specified offence by the offender is the concept for the imposition of the offence or imposition of the sentence.
Right.
So that's quite granular and quite detailed. The release provisions are not so constrained. So it's a more general protection of the public from serious harm, both at the original release point under 18.4 and on the release after recall in 28(6).
Sorry, I mentioned recall, but it's the same, isn't it?
Yeah, it's the same. So both the exit points, the parole commissioner's judgment is a more generalised judgment about the risk of harm, but the imposition of the sentence is more constrained. So the underlying point, I suppose, is a court takes great care about the circumstances in which it imposes an ECS or an ICS. It's a high threshold with those components. Once you're in the system, then release is contingent upon a general assessment of serious harm, life and limb harm.
Although it's qualified by the phrase "no longer necessary,"
Yes.
which takes you back
To where you started.
the original necessity, which was governed by the more specific formula. It makes you wonder whether it's just actually shorthand.
It may be implicit. Possibly, yes.
Because it's not very clear. Serious harm means death or serious personal injury.
Physical or psychological, yes.
Yeah. And I just wonder whether can be offences where that is caused or brought about that aren't specified offences. And that seems slightly unlikely.
It's not impossible, but
Yeah.
I mean, the more natural reading seems to be the gateway into one of these regimes is through the highly structured provisions of either Article 13 or Article 14. Once you're within it, what the parole commissioners are excluded from doing is conditioned just on whether there remains a necessity of detention for the protection of the public just from serious harm.
Yes.
So no longer constrained by that highly structured entry point.
once you get through the entry point, you're classified as a dangerous offender, to which a public protection sentence applies. So it may follow that it's the more generalised test for exit or release.
Yeah, and again, you have more than once now referred to it as the test.
Yes.
But I think your submissions before are it poses a limit to what the commissioners may do. It doesn't actually set the test that they should apply. That's a matter for their choice as a matter of policy.
Yes. Pausing there, just reflecting on the exercise we're engaged in, all of this is being done to test whether or not the DCS is analogous or the same as the ECS. And the more we get into the detail of this, we say it makes the point very clearly that the ECS is self-evidently different from the DCS. And the ICS has additional elements in respect of that. So, coming back then to, sorry, I was on 18. A further distinction can be found in Article 19. This is page 1010. Power to release prisoners on licence before required to do so. And this is a facility provided by the 2008 order for the prisoner to be released on licence at any time during the period of 135 days, ending with the day in which they will have served the requisite custodial period. And this doesn't apply to an ECS prisoner. So if you're the DCS prisoner, the worked example I'm giving of the 2 years plus 2 years, you could count back 135 days from the end of whatever the custodial period is, and there's a facility to release for the DCS. No such facility for the ECS. So again,
presumably the prison rules, you could operate those in order to
yes,
to release on licence.
on an ECS prisoner.
Or an ECS
yes,
prisoner.
you can. There's a facility for that. Yeah. But under the structures,
there's a different statutory regime.
Yes, under the structures of the legislation, this facility is made available for DCS. Again, I'm highlighting the points of distinction and demarcation between one and the other, and this is another signifier in that respect. I don't think I need to say much about the licence conditions or periods. The licences are obviously different in duration across the 3 sentences that are in play. You'll see Article 22, page 1018. It deals with the licence periods for the ICS prisoner. An ICS prisoner has a licence that remains in force for the remainder of their life. The ECS prisoner has a licence period that remains in force for the extension period. And the DCS is constrained by the outer envelope of the imposed sentence. So the licence periods are different, again, as a feature of the statutory scheme. Coming then to Article 28, which is where we started this analysis. This is the target of the challenge. You will see again the consistent application of these concepts from beginning of sentence through to end. The recall provisions under 28 refer to prisoners released under licence under Article 17, 18, 20 or 20A. So that's all of these sentences. The DCS, ECS, ICS are all dealt with under the same provision. Subsection 2 is about the recommendation process. I've shown you how that worked in practice in this case. 5, subsection 5, where there's a direction from the Parole Commission for immediate release, the Department should give effect to it. And then 6 has been the focal point of the discussion. And here again you can see 28(6)A refers to the indeterminate custodial sentence or the extended custodial sentence, and the concept is that the Parole Commission should have regard to whether it's no longer necessary for the protection of the public from serious harm that P should be confined. So serious harm is the gateway concept, albeit with the additional ingredients. That's the concept that applies at release age. That's a concept that applies after recall when considering release again. That's a consistent feature end to end of those sentences. One looks then to 28(6)B, and one can trace this right back to Article 8, subsection 5, which is the application of the harm, protection of the public from harm concept. The release is automatic, so there's no qualitative assessment or judgment in respect of that. The licence conditions will reflect harm. If you're recalled in respect of that, then the consideration for the parole commissioners is whether or not it's no longer necessary for the protection of the public that the individual should be confined. It doesn't actually use the word harm, but when one looks at the whole scheme from Article 8 right through to the end, that is the metric that's used for considering release after recall. But it's different by design, consistently so, from one end of these different sentences to the other. And I'll come back to how that fits into the jurisprudence on analogous situation in a moment. Pausing there, the appellant's case, which we've canvassed this briefly before the short adjournment, is that you collapse this distinction at 28.6 and you apply a risk of serious harm test to both. Outworking of that, as I've indicated, is that the recidivist offender, like this offender, involved in serial vehicle crime, not life and limb crime, who demonstrates a real risk identified by the parole commissioners, cannot be recalled. That's the outworkings of this argument. And we say, how does that sit with the carefully calibrated scheme that Parliament has enacted in the 2008 order? It actually undercuts the protective element from the DCS sentencing scheme.
Well, if Article 28.6 leaves it open to the parole commissioners to devise their own discretionary standard, which I think you say it does,
yeah.
Is that right? Then exactly what is the discretionary standard that they apply?
Well, what they
Or
do,
apply?
They've taken the standard from the statutory provision. That's what they apply. They haven't developed or adopted a different one. They use that as their touchstone, and that's a reasonable approach for them to have adopted. It aligns with the statutory scheme.
Well, it may do in relation to B, but I have my doubts about A. Why is the recidivist who presents a risk to the public, though it's not serious harm, why is he immune from recall?
Well, that prisoner will have been subject to an entirely different sentence journey. They will have been sentenced on the basis of risk, managed in respect of their risk, should have been subject to rehabilitative work, will only be released if the parole commissioners are satisfied that they don't pose that risk, and recall follows in the same framework. That's the rationale for it.
I'm just concerned that the parole commissioners are releasing people into the public who don't present a risk of serious harm, though they recognise they present a risk of harm, and then don't recall them, even though they do present a risk of harm.
Well, it's not the case we're facing, my lord, here, but when one starts to approach this and with an Article 14 argument, you can level up or you could level down. There might be a different argument to say, well, actually, you should level down the. That's not the case we're dealing with. You could level down A and say, actually, it should be harm for both. But there are reasons not to do that, because Parliament has imposed this structure, albeit with the discretion.
It hasn't imposed it. It's left at discretion to the
Yes, well.
Anyway.
Just to pursue that very shortly, I mean, I'm not sure it makes a lot of sense for the commissioners to tie their hands to the statutory limit on their discretion in this way, because you can imagine a situation where even within, going back to your example, you've got the DCS 4 years, released automatically at 2 years, thereafter on licence and subject to the test as a minimum, as an outer limit in 28(6)(b). Yeah. So ordinary, just any harm, they can be recalled. In the case of an ECS person, they might be released after 2 years, provided the parole commissioners think they don't represent serious harm. They reoffend in the same way as the person who's subject to a DCS sentence in the same period. It would seem most odd that they can't be recalled, even though they're the more serious offender. They're representing the same, at that stage, the same risk to the public. Anyway, as you say, it's not the case you face, but it just seems odd that the commissioners seem to have got themselves into this position. That's
a discretionary, that's a policy approach they've adopted. The statute has the facility. Yeah. It's available. If you wanted to say, well, less than serious harm is sufficient, that's a prospect. That could happen. Yeah. So you could level down without any kind of compatibility findings here, or convention issues. The scope and the discretion to meet the need in terms of public protection, it seems to us. So the Commissioner's policy of 2011 may be something that warrants reconsideration.
But I just wonder if it is, actually, even in that situation, in any sense illogical. They're only ever in prison because of a certain standard a certain threshold that's been crossed. So why would one pull them back if that same standard isn't being met?
Well, they would have been in prison either way. So let's say the threshold wasn't crossed and it's the granular threshold of specified offence, they would have been in on a DCS.
Yeah.
So they would be there, but not under the dangerous rubric. So yeah, that's why it probably works as a matter of logic, I think. So,
they wouldn't be there with the same jeopardy.
No, they'd be in a different position, but they would still be in custody with a different framework. That's probably the last thing I need to say in respect of the statutory scheme, I think. But if I can just draw some of that together, our submissions in respect to this is these different sentences in the 2008 order, and there are multiple different sentence regimes, have to be looked at holistically. That's what STOP tells us. We say these different regimes, DCS, ECS, ICS, have different rules about when they can be imposed, different threshold conditions that have to be met before they're imposed. ECS and ICS have threshold conditions for dangerousness and public protection, which DCS do not. DCS has provision for automatic release at the end of the custodial period. ECS and ICS require qualitative parole commissioner assessment. Each of the sentencing regimes has distinct provisions in respect of release on licence. DCS linked to harm, ECS and ICS linked to risk of serious harm. The consequences of recall while on licence are different. The DCS prisoner serves the remainder of the sentence. The ECS prisoner is at greater jeopardy, and the ICS at greater jeopardy still of serving an extended custodial period. And in brief, we say these are plainly different sentences. I'll factor that into the Article 14 analysis in a moment. Pausing there and going to potentially short answer on the point in this case, and that's the consideration of margin of appreciation. The Strasbourg authority that's been open to the court is today primarily is Clift in the United Kingdom. Clift in the United Kingdom deals with margin of appreciation at Sorry. This is at 1, 3, 2, 6. Paragraph 73. It's a general consideration of justification, but the last 3 lines of that paragraph are cited and recited in later authorities. While in principle a similar wide margin of appreciation applies in questions of prisoner and penal policy, the court must nonetheless exercise close scrutiny where there is a complaint that domestic measures have resulted in detention which is arbitrary or unlawful. So this is a measure of prisoner and penal policy. It falls within what the Strasbourg Court considers to be a wide margin of appreciation, subject to the check that we're looking for arbitrariness or any illegality in its application. So we're in the zone of a wide margin of appreciation.
Is this in the section of the judgment dealing with justification?
Yes, it is.
So, just so that I can get it clear in my mind, if one, insofar as one's looking at the analogous situation question, margin of appreciation doesn't apply to that, does it? Because that's a matter of legal analysis.
It applies to justification domestically, but I'm saying it also applies at a prior stage, just at the general entry stage of the analysis. If we're looking here at a piece of, we say, primary legislation, which is within the margin of appreciation as a piece of penal policy, then that engages, we say, the analysis that Lord Reid put forward in SC, and I'll take you to that.
Okay, just before we leave Clift, though, there's nothing you wanted to show us in Clift which shows that margin of appreciation applies to the analogous situation.
No, I'm not suggesting it does. I'm going to come back to analogous situation in a moment. Just before we get to that, just as an entry concept, because we say this can be a complete answer on the point. This margin of appreciation issue is picked up and applied by Lady Black and Stott. Don't need to go to it right now, but the reference for the moment is at 1277, paragraph 153. Return to that. But I'm taking the court to the approach of this court in SC, the discrimination Article 14 case, Lord Reid's judgment, paragraph 144. That's page 1207.
Sorry, 12.
1207.
Thank you.
And reference here to the approach of domestic courts and margin of appreciation. Refers to Baroness Hale and Countryside Alliance, where we can reasonably predict the Strasbourg Court would regard the matters in the margin of appreciation left to Member States. It would seem this House should not attempt to second-guess the conclusion Parliament has reached. And explains why. So that's...
But that, I mean, that's looking at justification as well, isn't it?
It can be justification. It can factor into justification. But in a sense, it's a simpler answer to this kind of case. It goes to the question of potential breach. And the same point is picked up at 144. Lord Reid's second reason, the need to respect the separation of powers between the judiciary and elected branch of government. They have to accord appropriate respect to the choices made in the social and economic policy by the government and Parliament, by giving a safeguard against unjustifiable discrimination. This is one of those cases, we say, where a court can determine that there's no breach because this is squarely within the domestic margin of appreciation.
In relation to justification?
No, not even justification. Generally speaking, is there a breach or no breach at a level of generality?
I have to confess, I'm just struggling to follow that submission. And you haven't shown us an authority that says when one's looking at the analogous situation part of the test, a margin of appreciation applies there as well.
It doesn't.
Is there any authority?
It comes back in a justification. That's
right. Okay. I mean, I follow the submission you're making on justification, but
that's where it lands.
All right.
So I'm making that point because the margin of appreciation concept frames everything that follows in the later, except for the analogous situation judgment. We say this is penal policy. This is directly and carefully constructed, and it goes to fundamental question of breach. Turning to the analogous situation point, rehearse again the classic Article 14 rubric, questions of ambit. status, analogous situation and justification. In this case, it's the latter two that are in play, analogous situation and justification. But status is not irrelevant. Before I move on to those questions, just flagging where status sits in all of this. In Stott, 4 of the 5 justices considered that there was a sufficient status for Article 14 purposes. Lord Carnwath didn't, and he's given quite a careful judgment on that, and you will find that from 1278 onwards. And he's expressing scepticism about the Strasbourg Court's analysis on status based on dangerousness as an offender. He's struggling to see why the Strasbourg organ should protect, in human rights terms, dangerousness as a concept or a status. And Lord Hodge expresses some sympathy with that view, but ultimately doesn't go along with it in terms of the rulings in the case. I flag this for this reason. We're not seeking to re-argue the status point in this case, but the nature of the status relied upon is relevant to justification. And the status relied upon here is status as a particular type of offender, not a dangerous offender, compared to a dangerous offender. And we say that is not a suspect characteristic. It is something that is at the what Lord Walker described as the outer orbit of the concentric circles of what Strasbourg protects under Article 14. Therefore, all the easier to justify.
Can you remind us where Lord Walker, what was the case?
Yes,
where Lord
it's
Walker
RJM. I'll give you the...
Oh, yes.
So
Sorry, sorry, you good.
2436, I think, in the bundle is the paragraph 5, Lord Walker in RJM.
It wasn't really picked up and used in SC,
No.
concentric circles.
No, it wasn't.
It wasn't. No.
Although there's quite a lot of discussion about suspect characteristics and giving weight to those that are at a particular end of the spectrum.
No.
And we say, whatever way we want to approach it, whether it's concentric circles or the approach Lord Reid used in SC, the status that's relied upon here is not something that's innate to the individual. It's not a core characteristic. It's something that is being done to them as a matter of penal policy. Therefore, the justification that's required can be calibrated accordingly.
So the submission is that, in a sense, the less clear-cut it is that it's within the status, the more likely it is that one is going to struggle to, or the more likely it is that you're going to find the justification.
Yes, the easier to justify it is.
Yeah.
This is all we say, very peripheral to the
Yeah.
core issues that are protected by the values of the convention. Lord Carnwath thought it shouldn't be protected at all, but that's not what the majority found in Stott. So we say where state of status plays into this. Moving then to analogous situation. Analogous situation is the centrepiece of the consideration in Stott, and we say the reasoning in that case on that point is directly applicable. Stott's a challenge to the application of early release provisions, not recall provisions. The analogous situation is dealt with from page 1258 onwards in Lady Black's judgment. Picking it up at 1266, I'm not going to read this out, but the arguments advanced on behalf of Mr. Stott are set out at paragraphs 115 and onwards, and they are analogous to some of the arguments that are being advanced before this court. Reliance was placed heavily on a divisional court decision in the case of Foley, which in his written case Mr. Southey continues to rely on and contends that the Supreme Court didn't reject Foley in this case. The Secretary of State's arguments are set out from paragraph 118 onwards. Picking up at page 1268, you have the discussion section. And as I say, it's in the written case of the appellant that Foley is still sound and that the Supreme Court didn't decide that it was wrong. That's paragraph 54 of the appellant's written case, page 117 of the bundle. You don't need to go to it. Just useful to look at what Lady Black said about that. So the argument being made was a DCS sentence, a determinate sentence, is broken into two components, a punitive element and a risk element. The punitive element being the custodial period, the risk element being the licence period.
Sorry, we're reading Lady Black at 1.
Lady Black at 122, my lord.
Thank you.
You'll see the Secretary of State's argument at 123 was that that didn't apply to determinate sentences.
So are you saying that 122 is referring to the analysis in Foley?
It is, yes. 123 is the Secretary of State's submission against that. 124 is Lady Black's acceptance of that submission. And then she goes through a lot of Strasbourg authority, but going to 1271, paragraph 133, having reviewed the authorities, it's fairly clear the Strasbourg jurisprudence is against the two-component analysis so far as determinate sentences are concerned. In other words, a determinate sentence is not punitive and risk, it is entirely punitive. She then said viewing the whole term as punitive would also be consistent with the generally applicable purpose of sentencing set out in the 2003 Act. She then picks that up again at paragraph 144. Like the reasoning of the Divisional Court in the present case, the view of the Divisional Court in Foley cannot be dismissed lightly, given the enormous experience the judges in those two decisions have in criminal work. But for the reasons I gave earlier, I would question the two-component analysis in which the courts proceeded. So that's a gentle way of saying Foley was wrongly decided and the sentence is entirely punitive. We say that's right for this case. The DCS sentence here is punitive end-to-end. The ECS is not. It has a punitive element and a risk element, and that's important for the analysis. That approach was supported by Lord Hodge.
It's just a little bit difficult because a punitive sentence is structured on the basis of deterrence, retribution, and risk.
Yes.
And so you're correct, it's all punitive, but it does...
It has a collateral risk reductive effect. Yes.
Involved in it, yeah.
But there is an element to the ECS that is risk reductive only. That's the extension period. And again, if we're looking for a philosophical, conceptual distinction between the sentences, that's where it's found. And that's what the majority of the Supreme Court found in Stott. Mr. Sully's argument says it didn't, and that's, we say, not correct. And we point to Lord Hodge, page 1286. Paragraph 186, picking it up in the second sentence. Lady Black has helpfully set out the different types of sentence which a judge in England and Wales can impose in paragraphs 84 to 105. I agree with her analysis in paragraphs 123 to 134 that a determinate sentence cannot be divided into a part relating to punishment and deterrence on the one hand and the avoidance of risk on the other. The idea that a punitive and deterrent part of a determined sentence ends at the point of entitlement to, or at least eligibility for consideration of earlier release, is central to Mr. Southey's case and the reasoning of the Divisional Court. In my view, the idea is not correct. Lord Carnwath, making up the third judge in the majority, page 1284. 1284, paragraph 180, simply agrees with the reasons of Lady Black and Lord Hodge on analogy and justification, and we say that's to be taken as an agreement with the rejection of the two-component analysis and acceptance that there's a difference between a determinate sentence and an extended sentence, and the difference is the extended sentence has an element that is purely risk-based. So, pulling back, transferring that analysis to our case, which is not about release but about recall, the same considerations apply. The appellant's case seeks to compare the sentence that is wholly punitive with that which has a punitive and a risk reductive element. And the Supreme Court in Stott said that fails. Going back to Lady Black's careful judgment on the point, I broke off on her analysis at page 1274, paragraph 144. I won't read it, but 145 is really getting to the essence of the issue. And what she's saying is you need to analyse the sentences, the different sentences in detail. And she's observing each one has its own detailed set of rules, dictates when it can be imposed, how it operates in practice, the early release provisions being part and parcel of the rules. It says some sentences can only be imposed when the offender has already committed offence of a particular type. For some, there's automatic early release and licence. For others, releases depend on the parole board. Those serving indeterminate terms remain on licence, liable to be recalled to prison for the rest of their lives, whereas other offenders will be on licence for a finite period only. All of this fine detail tends to support the Secretary of State's argument that each sentence is tailored to a particular category of offender, addressing a particular combination of offending and risk. And we say that's exactly the same position that applies here. So the issues addressed again in detail at page 1277. Paragraph 153 goes back to my margin of appreciation observation at the outset of this convention analysis. Lady Black saying the starting point for determination of these questions is that the European Court of Human Rights would allow a contracting state a margin of appreciation in assessing whether and to what extent differences in otherwise similar situations justify different treatment, and allow a wide margin when it comes to questions of prisoner and penal policy, although closely scrutinising the situation when the complaint is in the ambit of Article 5. And 154 depends whether you look up from the detail to consider the various sentencing regimes as complete regimes, and she's convinced that's the proper way to do it. And again, at 155, by letter H, reaches the conclusion that EDS prisoners cannot be said to be in an analogous situation to other prisoners. Most influential in the conclusion is rather than focusing entirely upon the early release provisions, the various sentencing regimes have to be reviewed as whole entities, each with its own particular mix of ingredients designed for a particular set of circumstances. We say that applies exactly here, save for the fact we're dealing with a recall rather than release. And what my learned friend is inviting the court to do is segment these sentences, zero in and focus on recall, identify an operational difference, and use that as a platform for a finding of a convention breach. We say that's not supported by authority. On approach, in passing, Lady Black deals with analogous situation and then justification, and then goes back to analogous situation again. She moves between the two concepts, doesn't adopt a doctrinally sealed approach. Lord Hodge, who gives the other substantive judgment, focuses on analogous situation, picking his judgment up at 1286. Again, rejects the idea that you look only at the early release issues and disregard the fact there are sentencing schemes. I've already shown you the Foley paragraph, or the Foley reference in the same paragraph. Paragraph 193, page 1288. Again, refers to the fact that there are separate sentencing regimes in England and Wales, as there are in Northern Ireland. It's appropriate to take a holistic approach to each in deciding whether or not one regime is analogous to another. And he sets out his reasoning on that. Paragraph 195, page 1289, he sets out his conclusions as to why EDS, determinate sentence prisoner, is not analogous to a prisoner under different regimes. He sets out his considerations. Probably the third is the most opposite for our purposes. It's because the prisoner sentenced to an EDS is under a statutory regime which, when viewed in the round, has materially different characteristics from other determinate sentences, and from life sentences both discretionary and mandatory. In my view, the obvious and relevant difference between the sentencing regimes are sufficient to prevent prisoners under these different sentencing regimes from being in an analogous situation. So he approaches it that way. That would be dispositive of the Article 14 claim, but he goes on to consider justification. Noting at 196 it's not strictly necessary because of what he has found. 198, he goes back to wide margin again. So it's within wide margin, no breach, referencing back to Lord Reid in SC. At 199, he touches upon the legitimate aim of that statutory scheme, the 2003 scheme. And you'll see, picking it up halfway down, Parliament's entitled to have regard to both public protection and to the maintenance of public confidence in criminal sentencing. The preservation of public confidence is a legitimate aim, at least in the context in which the custodial term, which is appropriate for the offence, has not expired. The 2008 order, which we're dealing with, and I referred you earlier to Mr. Allison's first affidavit, was very much tailored to concerns about public confidence. His affidavit, and indeed the parliamentary materials, refer to a particularly notorious murder committed by someone who was just released on licence without any supervision. The legitimate aim of the 2008 order is public confidence in sentencing. Paragraph 200.
What's the legitimate aim of the difference that is between determinate custodial sentence and indeterminate custodial sentences?
Well, it goes to the point we've touched on several times, to ensure that the recidivist offender on a DCS is subject to recall whenever the risk of harm threshold is met.
But not a recidivist offender who is subject to an extended or an indeterminate custodial sentence.
Subject to the policy approach that the parole commissioners adopt. Doesn't give rise to convention incompatibility. That's where that goes. So we say the factors which Lord Hodge found to warrant justification are factors that obviously apply in the 2008 order. We don't need to articulate more than that. Bearing in mind margin, everything that's been said about that. And we say this scenario is readily justifiable. Lord Hodge makes a useful and interesting observation in paragraph 203. Again, that case, like a lot of these sentencing cases, there are always anomalous issues at the margins that are thrown up because of the way these schemes work. And he deals with that at paragraph 203. I won't read it all out, but just by letter D, he observes that Article 14 doesn't, in my view, provide an answer to this problem as a particular anomaly that arises in that sentencing regime. Not every anomaly in sentencing is a breach of ECHR rights. So there will be marginal issues. And that's because sentencing schemes have to be generated at the level of wide-ranging rules. And wide-ranging rules will always have some suboptimal marginal problems. But that does not translate to convention incompatibility. Certainly through the Article 14 rubric. So I know we've been exchanging observations about potential anomaly in respect of serious harm considerations. Be that as it may, it doesn't get one to Article 14 breach. So our submission is that taking the same analytical approach the Supreme Court took in Stott, taking a fine textured analysis of the order and the differing sentencing regimes, applying that through the Article 14 rubric, the obvious answer is these are not analogous sentences. Therefore, Article 14 fails as an argument. We've had an excursion into argument about sequencing. I don't intend to spend time on it. We say a court can select justification first or analogous situation first, or as Lady Black did, move back and forth between one and the other. But a finding on any of them, a negative finding on any of them, is dispositive. And the approach our Court of Appeal adopted was the largely orthodox one of looking at analogous situation first, justification second, and finding a failure in an analogous situation. Again, nothing we say to criticise the Northern Ireland Court of Appeal for there. Come back, if I may, to the question of the nature of the challenge. The challenge is to, it seems to be initially in any event, to the compatibility of the legislation. And obviously if the court's with us, that it fails in an analogous situation, then the debate can stop there. If the court's against us on that, then there does need to be, in our submission, some reflection on the question of whether or not this is primary or subordinate legislation. Because if it's primary legislation, then the criticism of the Department of Justice goes nowhere, because they could do nothing but apply the law as it stood, and the Human Rights Act recognises that. If it's subordinate legislation, then there's a facility for reading in, or there's flexibility that can be built in respect of convention compliance, and the department doesn't have an answer to that. So I appreciate that my learned friend to an extent sidestepped the issue in submissions this morning. I'm not so sure it can actually be avoided if the court's against us on the convention point. And if the court is against us on the convention point, then our submission is this is primary legislation by operation of Section 21 of the Human Rights Act. There are two authorities in the Northern Ireland Court of Appeal which point in slightly different directions on the point. Lord Stevens referred to them earlier on. Decision of Lord Chief Justice Morgan in a case called Close, and a decision of the Lady Chief Justice in a case called SV 2023.
I think I have got to put
SV. SV for Victor.
V for Victor.
Yes.
SV 2023.
Yes.
And do we have those in the bundle?
We don't have them in the bundle because, for whatever reason, we didn't anticipate the point emerging in the way that it has emerged.
Those go in opposite directions.
They do. Although both of them are slightly opener observation, neither of them I would consider to be definitive on the point. But there they are. One lays emphasis on the Northern Ireland Act provision, yes, pointing towards subordinate. The other on the Human Rights Act provision, pointing towards it being primary legislation. Now, this is an issue which if the court is grappling with this in light of its primary findings, we could submit a short note on our position in respect of that, rather than develop it in an unstructured way now.
I think at this stage we'd be assisted if you could provide us with the authorities.
Yes, we'll do that.
And if we want a note, we will be in touch.
Yes, very good. We'll take that course.
Unfortunately, Close was a decision, Mr. McLean, that I agreed with.
Sorry, the later decision?
And I was a member of the court in Close. Be that as it may.
That's noted.
Yeah.
Yes.
It might be said that it wouldn't be particularly satisfactory for us to try to resolve that dispute without having adversarial argument on it. And
yes,
Mr. Southey isn't presenting us with that argument. His challenge now seems to be to something else.
Yes. Well, I accept that that's a position. It's slightly unsatisfactory if the court, because the department have an answer if it's primary legislation, to the fact that they couldn't have acted differently. The other point, I think the court raised a query with me about the parole commissioner's decision. The prisoner was recalled in this case. He remained in custody. He was recalled based on the harm threshold. There was no challenge to that by the appellant. He remained in custody and served the outworkings of his sentence. Yeah. And he was, I think, subject to Parole Commissioner review, and they refused release. So we're dealing here with an intervening stage in his sentencing journey, and we're focusing in on the approach to recall by the department when actually the operative decision that kept him in custody is unchallenged by the appellant. He remained in custody on the Parole Commissioner's recommendation. They reviewed it and they maintained him in custody, applying the harm test. So that's a background factor. Lords, I think slightly short of time. I've probably covered the ground I needed to cover, unless the court has other questions for us. Those are.
I don't think so. Thank you, Mr.
Could I just check one point? Taking the point about the slight change in focus of the appellant's case, I'm just wondering whether the respondent, and it's the Department of Justice and Ministry of Justice, had any choice in the matter anyway, as things fell out. Am I right in thinking the parole commissioners are not a party to these proceedings?
Yes.
Is the effect of Article 28, subparagraphs 4 to 6, that once the Secretary of State has passed the matter, referred the matter to the parole commissioners, it's basically the ball is in their court and they decide what happens?
Yes.
And the Secretary of State has no further role in the matter? Or does the Secretary of State have a discretion somehow aside from what the parole commissioners decide?
Well, Secretary of State has no role, so it's the devolved Department of Justice role, but they don't have a role. Once it passes to the
same question.
Yes.
All right,
Once it passes to the parole commissioners, that the matter is beyond their control at that juncture. It's in the hands of the parole commissioners.
Right.
But we're dealing with the very narrow point of making the recall decision into the parole commissioners, at which point they considered themselves to be constrained by the legislation.
I mean, they are constrained by the legislation, aren't they, under 28.4?
Yes, they are.
Whether convention rights are engaged or not.
Yes, that's correct.
So there's nothing else they could have done?
No.
All right. Okay. I
think that's right, Lord, yes.
Just going back then, just to the recall provision, which is Article 28?
Yeah.
Yes.
Page
1028.
1028, yes.
1028, just give me a moment. Yeah, okay. So, irrespective of whatever policy is being exercised by the parole commissioners, the Department of Justice has its own discretion to exercise as to recall. Is that right?
Yeah.
May revoke and recall if recommended to do so by the parole commissioners. So,
yes.
And so the challenge appears to be more to the policy of the Department of Justice to revoke.
The Department of Justice,
rather than to the legislation.
There's an untidiness to how this works out because the High Court ruling, essentially, of Mr. Justice Colton, was to the effect that the Department's approach should be to apply the 28.6b analysis. So that's what the High Court said. It wasn't subject of an appeal, so that's taken as the baseline position for the Department. That's how we've got to this position. So that's predicated on the finding of the High Court in this case, not challenged in the Court of Appeal.
Okay, but that looks slightly confusing to me just as I'm sitting here reading it, because the power of the Department of Justice is in 28.2, may revoke P's licence if recommended to do so by the parole commissioners.
Yes.
Or in the subcategory where you do something pending a decision of the parole commissioners.
Yes.
But the parole commissioners have not recommended release on licence. So is there...
They recommended revocation. So 28.2 is the revocation decision.
Sorry, revocation. I'm so sorry. Revocation. They have not recommended revocation. So is there any residual power, discretion in the Department of Justice to revoke the licence?
I thought that they did.
The Parole Commissioners did make a recommendation.
Oh, I'm so sorry.
Yes.
I'm so sorry.
The factual situation is slightly untidy. The Parole Commissioners made the recommendation, I showed you the reference just after lunch, to revoke. That goes to the Department of Justice, and they acted upon that.
The recommendation by the Parole Commissioners at that stage is done somewhat more quickly and somewhat without any investigative duty, as it were. So they don't have to contact the prisoner and they don't have to get information from the prisoner. At a subsequent stage, when the person has been recalled, the Parole Commissioners then have an obligation to consider both sides of the story.
Yes. So the first one's done urgently, and then it goes to the department. There's a more reflective consideration. Yeah. They concur with that view, and the applicant argued that in that exercise required the application of the 28.6 framework, and the High Court so found, and that's the baseline that we're working from.
You've shown us the guidance of the Parole Commission.
Yes.
Does the department have any policy?
There's no articulated policy on the point, no.
Yes, I'm so sorry. I'm still slightly struggling with the idea that the department has a discretion once they've referred the matter of recall under Article 28.4. So there's the initial revocation,
yes,
28.2. Once the prisoner has been returned to prison, under 28.4, the department shall refer P's recall to the Parole Commissioners.
There's no discretion for the department at that stage.
No. And then that rather looked to me as though the matter is handed over to the Parole Commissioners for them to decide, and the department has to act in compliance with what they decide to do.
Yes, that's correct. This debate is about the 28.2 consideration. So the recall on the recommendation from the Parole Commissioners.
Right.
So we have in this case an extant recommendation from the Parole Commissioners. You've seen that, indicating that the individual commissioner on the urgent basis was satisfied that the test had been met. Test's not the right word, sorry. That the harm threshold was engaged, and the department considered that, agreed and applied the recall. That's the real target of this challenge.
Right. So is it being said then that under 28.2, even though the Parole Commissioners have recommended recall, there's some discretion for the department over and above that to say, well, you've recommended that, but I'm not going to do it?
Well, the appellant's case is the department should say, well, actually, I know you've said it's harm, but we're applying serious harm.
All right.
Therefore, we refuse the recall. That's the case. All right. Yeah.
It may be helpful, Mr. McLean, Brian Kerr wrote a judgment in relation to this, whilst Lord Chief Justice or a High Court judge, in relation to the distinction between two and the different roles of the Parole Commissioner at the initial revocation stage and at the subsequent stage when the matter is when the prisoner has been recalled. And it might be useful if refresh my memory as to what that case was.
Yes. But you'll see, we will search that up, my Lord. On 28.2, you'll see that the department has a discretion, even on the recommendation. So you'll see the department may revoke the licence and recall if recommended to do so by the Parole Commissioners. So we've got the inbound recommendation of the Parole Commissioners, harm threshold is met, they recommend recall, the department has to exercise an independent judgment. The department say, okay, we'll do that, we'll apply harm as well. Mr. Sully says, no, you should apply serious harm. And if you apply serious harm, you can't recall him. That's the absolute nub of the case.
Yes, right, thank you.
Thank you, Mr. King.
Thank you, Lord.
I don't think there's anything else. Thank you very much, Mr. Sully.
My Lord, given those observations, can I start with just a little bit more perhaps about the nature of the challenge? In the Court of Appeal's judgment in a case called Rainey, which is at tab 29.
We have electronic numbers.
Oh, sorry, because I put in my notes. I'd forgotten. We'll find you the page number for tab 29. It's actually I've got it. I know where it is. It is page 2121.
Thank you.
What the Court of Appeal decided was that there were that effectively a prisoner has two ways of challenging their recall. They can, of course, make representations, and many of them will do, to the parole commissioners saying they should be released, but they can challenge the lawfulness of recall by way of judicial review, because the role of the parole commissioners is not to determine whether the department's decision was lawful. It is to determine whether the grounds for continued detention are made out. So if you want to say that the recall was unlawful, which is what you're obviously doing if you're saying it was a breach of Article 14, you have to do that by way of judicial review. That's why this has always been a challenge to the decision of the Secretary of State, because effectively, if the recall decision was unlawful, everything that flows from it would be unlawful. That's how you say I could never have been recalled lawfully, and that's the nature of the challenge. Now, what that means in terms of relief is that, having considered the matter, and it is in our written case, I refer to paragraph 66 of the written case, because ultimately this is a discretionary exercise by the department. That's why we recognise effectively that an issue of compatibility doesn't arise. The question essentially, because the focus is on the Department of Justice's decision, is whether that discretion was exercised in a manner that was compatible with Article 14. Can I also just very briefly answer my Lord Justice Lord Stephen's question about Lord Kerr as he became judgment? There is a reference to it because it was cited below. It is a case called Mullen, which is 2007 NICA 47. It's actually referred to, because it was relied on below, in the judgment of Mr. Justice Coulton at para 44, page 250. The critical point about that was that what that was concerned with was the procedure, and it echoed what my Lord in fact put, I think, to my learned friend, which is that it can be a pretty summary procedure recall. It wasn't concerned with the test, basically. Turning then to the test, because obviously that has become more of an issue. My learned friend in my submission on reflection correctly recognised that the Parole Commissioner's guidance at 478 of the bundle proceeds on the basis that that effectively it has no additional discretion. It simply applies the statutory language. I say that for this reason, for two reasons. Firstly, if one looks halfway down paragraph 4, it refers to the language of 28.6a and 28.6b. It then, at the bottom of paragraph 6, effectively sort of paraphrases that language to deal with the recall question. And the passage, the sentence that my learned friend referred to initially to suggest there was a discretion, where he says there's no test authorised, which is in line 4 of paragraph 4, what that's referring to is the fact that in 28.2, when the parole commissioners have a role, there's no test there. But what they do in this guidance effectively is apply the 28.6 guidance to their recall consideration, to their initial recall consideration, and they apply it as though it is mandatory. That was then essentially the basis of the appellant's argument below. The appellant argued essentially below that these tests were discriminatory. He did that in light also of the fact that the department, one of my lords asked about the whether or not there was any policy from the department about the test it applied. The department's there is no published policy, or there was no published policy as far as anyone was aware, but it's important to note, because you haven't been taken to it, that at 451, paragraph 31 onwards, the department's decision maker described essentially the approach that is adopted or was adopted by the department, because this in part is what was found to be unlawful.
Whose witness statement is this?
This is an affidavit of Stephen Allison, who's head of the offender recall unit. Essentially, he's the person who takes decisions on recall, as we understood it. He then says, although he says that there is a broad discretion, he says at paragraph 35, essentially, that the department has adopted the tests considered by the PCNI parole commissioners for Northern Ireland. So he refers back effectively to the guidance that you've seen. Albeit, the slightly odd feature of that was he also says, despite the fact that guidance clearly does draw a distinction between ECS and DCS prisoners, the department at para 37 doesn't apply a distinction, which was why there was this argument about whether there was a difference in treatment. That's the basis then of the High Court judgment, and the High Court judgment essentially proceeds on the basis that there is no discretion. The test is as described in the guidance, and we would say as derived from the legislation.
What do you say about, before leaving paragraph 35, that the risk of harm posed by the applicant had increased more than minimally? Well, if you've got an automatic release, you don't know what the baseline is. And why then do you have to have it increase more than... Why does it have to increase?
Well, my lord, that is... I mean, there is English Court of Appeal authority that suggests it doesn't have to increase, albeit... and I'm conscious of the fact it doesn't really arise in this case because it's not a straightforward issue. I mean, if there was literally no change, which is probably not going to be the case, it's very difficult to see how it could be justified to, the recall of a prisoner could be justified, because otherwise you're undermining the automatic release. You're making automatic release discretionary. If literally what happens is the prisoner is released at the door of the prison and immediately recalled, that would seem to be fairly arbitrary, potentially, and inconsistent with the objectives of the legislature. And that's not what the English Court of Appeal upheld. What the English Court of Appeal held was that you recall, but there has to be some reason for believing the prisoner poses a risk from memory. And I'd need to, I think it's a case called King from memory. But but that's obviously not an issue in one sense in this case. And what I was going to add, and in one sense that sets up where I wanted to go to in terms of this issue of whether there's a discretion under 28 or just the application of a policy. I would urge the court not to go down that route because it doesn't need to. Because
down what route?
The route of saying of considering whether or not there is a discretion, essentially, a broader discretion.
What, in 28.2?
In 28.2 or 28.6.
But I thought your case is focused on there being a discretion in 28.2.
No, my case is, because this is what was upheld in the High Court, is that the power of the department has to reflect 28.6, and as a result, those tests have to be applied, subject to the one qualification to that, which is that if that produces an incompatibility with the ECHR, because the language doesn't require that, compatibility with the ECHR can be achieved. But, my Lord, the discretion fundamentally I was talking about was that the court has raised the question of whether the language effectively permits continued detention, essentially, in circumstances where, for example, a prisoner, an ECS prisoner, doesn't pose a risk of serious harm, to paraphrase the statutory test. That, in my submission, is something that the court should be very reluctant to address, because it doesn't need to, because quite clearly on the language of section 28.6 there is a difference in treatment, and it's a deliberate difference in treatment, and you see that from the words at the start of 28.6b, which, by referring to in any other case, clearly intend there to be a difference of treatment. And the risk in my submission is that there is because this hasn't been raised, as I say, up until now, the matter has proceeded on the basis that essentially the High Court was correct to conclude that the appellant was correct to argue that the legislation, subject to Article 14, required effectively the department to consider in an ECS case whether there was a risk of serious harm, and in a DCS case, the protection of the public. The risk in my submission is that both in England and Wales and in Northern Ireland, parole board, parole commissioners, courts have all proceeded on the basis that there is no supplementary discretion. And if that is to be departed from, in my submission, it would need to be properly argued.
I mean, in a sense, neither party's case turns on this.
No, well, that's what I'm saying, my lord. It doesn't need to. You don't need to go there, because there is whatever else might be said, there is plainly a difference in treatment in 28.6, and the question is whether that's justified, effectively.
Yeah.
Well, turning then to the statutory scheme, and my learned friend's fundamental argument was that the sentencing provisions are, and this was his language, hermetically sealed. And so, to give an example, he says, look at Article 8.5. Article 8.5 provides that, essentially, that when setting a DCS sentence, the licence period that will be part of the sentence is there to protect the public from harm. If my argument is correct, that must imply that, in fact, during the licence period, the licence doesn't protect necessarily the public from harm, it's only serious harm. In my submission, the problem with that argument is that it ignores the fact that there is quite clearly a degree of overlap, I'll come on to that in a moment, between ECS and DCS prisoners. ECS prisoners in particular are obviously released only if they are held by the parole commissioners to not pose a risk of serious harm. But a licence needs to be imposed, and it's difficult to see, given that they are serving a determinate sentence, a sentence set to reflect the seriousness of the offence, why part of the DCS sentence, particularly during the custodial period, is not the protection of the public. And so, if it is the problem from my learned friend's point of view is that he can make the point about the release test, and the release test in relation to DCS prisoners in isolation may well be justifiable, but the question remains, why should ECS prisoners be treated differently and more favourably? Why should the recidivist, essentially, who's an ECS offender, not be subject to the same recall provisions? And with respect to my learned friend, when that question was put to him in that way, he struggled. He sought to justify why a DCS prisoner may be recalled, but that's not the question. In terms of the difference, he simply said, well, that's not convention incompatible, I think was the language used. And he pointed to he argued effectively there may be anomalies around the edges. Well, this isn't an anomaly. This is about the provision that's used to protect the public while an individual is serving a determinate sentence. Now, my learned friend, one of the things that perhaps underlies those questions about the sort of recidivist offender is, understandably, it's not a terribly attractive position or conclusion to reach, effectively, that there may be recidivist offenders who can't be recalled. But of course, one needs to remember in relation to the recidivist offender, if they're only receiving a DCS sentence, at some point they won't be recallable. They come to the end of their sentence, and no matter what the risk of reoffending, they are then at liberty. The protection that Parliament has decided, or the Northern Ireland Assembly has decided, is adequate, is of course the potential for a further criminal prosecution. And so, if you think about the straightforward DCS offender who's a recidivist offender, who receives, say, a 2-year sentence, at the end of 2 years, they may be highly likely to commit further acquisitive offences. If they commit those acquisitive offences, Parliament has said, well, that's not a matter to be addressed through the regime of the previous sentence. It's a matter that can be addressed through further prosecution. And so it's not, in one sense, because you're looking at two groups of determinate sentence prisoners, it's not surprising that there can be risks that effectively aren't addressed, because these are a group of offenders who, for whatever reason, the legislature has concluded should not be liable to detention for life. They're a group of offenders who are managed by further criminal prosecutions, if that is necessary. And
I struggle with that point. I mean, in a sense, obviously, when a sentence comes to its end, that's it. Whatever one thinks the risk might be, the prisoner's let out, and then we're reliant on new criminal prosecutions. But I'm not sure how that helps your case.
Well, my Lord, the reason it is, it's going to this point about the difference in treatment. There is nothing, because, as I say, there comes a point at which, with relatively low-level offenders, people who are low risk, or relatively low risk, because they serve a determinate sentence, Parliament has to recognise the point I was making, which is that there comes a point where their risk just has to be tolerated, and if it manifests itself in further offending, that's dealt with by way of a criminal prosecution. Now, because of that, it would be perfectly legitimate for Parliament to say, in relation to a DCS prisoner, you'll serve half your sentence at the end of that time. If you commit a further offence, you'll obviously be prosecuted, but we'll only recall you if you pose a risk of serious harm. That would be a legitimate decision for Parliament. That would be a parliamentary decision. Now, that's effectively what it has done in relation to ECS prisoners. And the question becomes: is there a basis for drawing a distinction? Because that is the position it's taken. And it's why, and that's important when learned friend spent a lot of time going through differences between sentences, but the question is, are they relevantly similar? And fundamentally, it comes back to the point that they're serving a determinate sentence and risk needs to be managed. Very quickly, Article 15 in that context, that is simply a concern with the assessment of dangerousness. It doesn't impose any additional features on ECS sentences. Turning then to whether or not the circumstances are analogous, it's important to recognise that in Stott, Lady Black, who in one sense, delivered what I argue is the leading judgment because it was adopted by Lord Carnworth and it ensured that there was a majority, quite clearly only reached her final conclusions regarding analogous circumstances after justification. And she reached that conclusion in circumstances where there was a specific justification put forward, which was the point I made before in opening, the point that is highlighted in Lord Hodges' judgment, essentially that the ECS sentence had a particular basis for it. And that's why my submission, one has to be very careful about simply doing what my learned friend wants to do and import the findings about analogous circumstances into this case. This is a case where ultimately on Lady Black's analysis there was a justification. This is a case where on our argument there is no justification, in contrast to Stott, where on Lady Black's analysis there was a justification for what was happening. Foley, I should say in passing, our point about Foley is, yes, it's true that Lady Black was critical to some extent of the judgment, its reliance on the two-component analysis. But the fundamental conclusion, which is at paragraph 76 of Foley, which is that there is no justification for a stiffer test for lower risk prisoners, that wasn't challenged, and that is part of Clift, and Lady Black...
What's the page number for paragraph 76?
Sorry, the page number is, the start of it is 1237. Sorry,
Yes, it's okay. Okay.
And of course, Clift makes exactly the same point. Fundamentally, Clift makes the point, again, that there is no justification for treating higher risk prisoners better than lower risk prisoners in terms of discretionary release, essentially. And that also wasn't challenged in Stott. What was, obviously, where my arguments failed in Stott was, I accept, in relation to the two-component analysis. But that's why, in one sense, I focused on DCS and ECS during the custodial period, because that's where Brown comes into play and demonstrates during those comparable periods, there is no two-component aspect to the ECS. The second component comes during the license extension period. But this recall test applies both during the license recall, during the license extension period, and also earlier. In terms of the margin of appreciation, in one sense, the simple answer to that is this. Clift started from the starting point that there was a wide margin of appreciation by referencing manifestly without reasonable foundation. It did that, but went on to conclude, despite that wide margin of appreciation, essentially you couldn't favour the higher risk prisoner, to paraphrase. Now, SC recognises that manifestly without reasonable foundation it is a way essentially of identifying a wide margin. See paragraph 160, which is at page 1211. the question always with marginal appreciation is how do you determine the boundaries of that? Because marginal appreciation simply means that there are a wide range of acceptable actions that the state might take. It doesn't say the state has limitless decision-making power. It recognises there are boundaries, and unusually perhaps in Strasbourg authorities, in Clift, and as I say, not challenged in Stott, one has very clear guidance about the limits of the margin of appreciation, where that principle about why do you about not treating the higher risk prisoner better, that is clearly stated in unqualified terms in our submission. And it reflects in our submission the fact that although there's a wide margin of appreciation, ultimately liberty is an issue, and it's important that detention of prisoners effectively is justified. It isn't applied in an arbitrary manner. And that goes back to the point, as I say, that in our submission is fundamental. Rightly, wrongly, and my learned friend has said, perhaps the approach to ECS prisoners could be changed to deal with the recidivist low-risk prisoner. But rightly or wrongly, there is a benefit following recall to being an ECS prisoner. The test that is applied is favourable to the prisoner. It focuses on the risk of serious harm. And fundamentally, there is in our submission no justification for treating that group of offenders, the group of offenders who are identified as being dangerous, that's the language of Article 15, more favourably, essentially, the DCS prisoners. Now, my learned friend, the one point he perhaps made that might be said to produce a justification is he said, well, the ECS prisoner is potentially recalled for longer. But of course, the ECS prisoner is only recalled if they pose a risk of serious harm. They have only been released in circumstances where it's been concluded that that risk wasn't present. So they've done something which has indicated that effectively that assessment was wrong. And in our submission, fundamentally, the problem with reliance on that longer period of recall is that longer period of recall it is only justified by the need to protect the public against a higher risk. They benefit essentially by not being recallable if they pose low risk, and there's no justification for that.
Can you help me with one thing?
Yes.
That is that in Stott, the comparator group and Mr. Stott had the same interest. That was in obtaining their liberty.
Yes.
Right? And they had the same complaint. Namely, they wanted to obtain their liberty. That's the general aim. Well, if you apply that as the test for what is an analogous situation, then Stott was wrongly decided.
Well, my Lord,
The holistic approach conflicts with your test, which is, I think, set out paragraphs 2C, paragraph 34, and paragraph 39, of relying upon the nature of the complaint to the exclusion of everything else.
well, my Lord, can I just qualify my answer slightly, and I in this way?
Yeah.
Lady Black, quite clearly, and Lord Carnworth endorsed her judgment, although he also endorses, it's fair to say, the judgment, I think, of Lord Hodge, clearly looks at justification first. And I think I've started by saying one can look at justification. Now, one of the reasons why one leads...
No, I wasn't on justification. I was just purely and simply on analogous. And your test for what's analogous is the nature of the complaint or the aim of the measure.
No, but
that would have resulted in a different outcome in Stott.
Well, no, the reason I was mentioning justification is that Lady Black does that as a way of, as a factor she wishes to consider in the context of analogous circumstances.
Yes.
Now that fits with SC in the sense that what she was looking at, in part, was the aim of the measure. Now the aim of the measure, see Lord Hodge, in Stott, was a very specific aim, which was to, or a very specific aim was, it wasn't the sole aim, but a very specific aim was relied upon to justify the difference in treatment in that case, which is extended sentence prisoners were treated differently because they previously would have been IPP prisoners, and so to maintain public confidence, automatic release at halfway was replaced with delayed, sorry, not automatic release, eligibility for release at halfway was replaced with eligibility for release later, but in return for that, there was automatic release at the end of the sentence. And so that group, because of that objective, essentially benefited from one point, lost with the other hand. Now that was in relation to that, if you focus on that in that way, there was a specific aim behind the legislation that meant that group were different to others because they had a particular interest in effectively no longer being subject to IPP. So their interests were applying SC in relation to the aim of the measure different. Here, one doesn't have any material along those lines seeking to explain the difference in treatment. One simply has a provision which on the face of it is there to manage risk, and it's in the context of a wider set of provisions which are intended to manage in particular the risk of higher risk offenders, and that's why I'm saying the difference that the difference to analogous circumstances applies. I think that's probably enough from me. Can I just check?
Thank you. I don't know if there are any questions. Thank you very much, Mr. Southey. Mr. Southey and Mr. McGlynn, we're very grateful to you and for all counsel in the case for your oral and written submissions. We're also very grateful to those sitting behind you for the preparation of the case. We will take time to consider and we will deliver our judgments in due course. Thank you very much.